Good morning, everyone. Emma, are we ready to roll?
Yes, you are good to get started.
Okay, thank you. Good morning, everyone. My name is Neil Rodgers. I'm the interim CEO of the Ontario Home Builders Association. And we have put together this webinar given a variety of developments that have emerged in the municipal, provincial world of government relations and advocacy, and particularly how it affects our members. Government relations and lobbying is an essential component of the land development and approvals process. The industry is highly regulated, and policies emerging from Queen's Park or local municipalities have consequential impacts on companies' business plans, negotiations, and discussions with policymakers, elected officials, and senior bureaucrats on a daily basis. Recently, the activities of the industry have cast a wider spotlight on the interactions with government and have been the subject of media inquiries and investigations by legislative authorities. The purpose of this webinar is to educate and inform OHBA members of their obligations in conducting lobbying activities with governments and managing the complex relationships and reporting requirements in place within Canada, Ontario, and an increasingly growing number of municipal jurisdictions. A few household items before we begin. Today's webinar is being recorded and will be made available after this session, along with the copy of today's slides. Q&A will be at the end of the presentation. Please submit your questions using the chat function at the bottom of your screen, and Emma Maynard will moderate the Q&A with either Kyle or Guy responding accordingly. I'd like to now introduce our speakers for today. Guy Giorno's legal practice is devoted to political law, specifically lobbyist registration, lobbying ethics, government ethics, and conflict of interests, and government transparency. He has served as a chief of staff to the Prime Minister of Canada and is currently an adjunct professor at Carleton University. He's been practicing law for nearly 33 years and has been a partner at Fasken since 2002. Joining Guy is Kyle Morrow, an associate at Fasken's. Kyle's legal practice is also focused primarily on political law, anti-bribery and corruption law, and criminal and quasi-criminal law. He has acted for a number of politically exposed clients in high-profile ethics, lobbying, and corruption-related investigations. I'd now like to turn it over to Kyle and Guy, and we appreciate your time and your insights during this presentation. Thank you.
Well, thanks so much, Neil, and just confirming that everyone can hear okay. Perfect. Okay, so I'm just going to start with just an overview of today's presentation. And as Neil noted, the goal of today's presentation is to provide a high-level overview of the lobbyist registration requirements at the municipal, provincial, and federal level, both the requirements that apply to the OHBA, but also requirements that may apply to your individual companies or your employers. And so just in terms of an overview, this is kind of how we've divided the presentation up. Again, we're happy to answer questions at the end of the presentation. We just ask, though, that given the presentation is being recorded, that when you have a question and you're putting it in the chat function, that you just be mindful of sensitive information and that it will be recorded. So please don't put any sensitive information in the questions and answers. We're going to start off with just talking about where lobbying is regulated. It's obviously regulated at the provincial and federal level. It's not regulated at all municipalities. So we'll walk through where it's regulated. We'll talk about the types of lobbyists. And under this section, we'd like to pay particular attention to when you are a lobbyist for the OHBA and when you are a lobbyist for your member company. And that's an important distinction. And sometimes you can be a lobbyist for both. We'll talk about what is lobbying. So what does the law define as lobbying? At the municipal level, we will pay particular attention to permits, licenses, and other development matters. So when are those communications covered? We'll talk about the legal, financial, and reputational risks arising from non-compliance. We'll do a brief overview of how you get your company registered if you're not already registered and what sorts of ongoing filings need to be done. And we'll conclude with just a brief overview of the ethical restrictions. So once you're lobbying, what are the rules around gifts? What are the rules around political activities? What are the rules if you have a family member, for example, who works in the government?
So why don't we start with where lobbying is regulated in Ontario? We're going to talk about federal lobbying, provincial lobbying, and then in a number of municipalities in Ontario, lobbying is regulated at the local level. Here's a list of all the cities, the regional municipalities and towns that currently regulate lobbying. You'll see an asterisk by the city of Barrie. It has approved a lobbyist registry bylaw, and that takes effect on January 1st of the new year, so in less than 1 month. The next slide just shows a few other places in Ontario where we're tracking the development of lobbying registration. Town of Blue Mountains is next. They approved a lobbyist registry in principle early last year. They did public consultations in April, and they've asked the town staff to come back with the final text of a bylaw next month. So we expect that there will be a lobbyist registration regime in the town of Blue Mountains sometime in 2024. We've also listed Caledon, town of Caledon, city of Guelph, and the city of Markham as jurisdictions where council has expressed an interest to the extent of asking the staff to come back and report with options and wording on how to do that. So we're tracking that, and other municipalities continue to debate these things at council as time goes on. Want to next switch to the question, as Kyle said in the overview, what are the different categories or types of lobbyists? Lobbyist registration laws and bylaws really put people into 3 categories. And the categories you go into are based on, if you go back just for a sec, Kyle, what it is your connection is. What is your connection to the association? What is your connection to the company that you work for or that you own? And when are you maybe lobbying for both at the same time? So 3 categories to think about are people who are lobbying or talking to government, city, provincial, on behalf of their employer for pay. People who are doing it for an entity that pays them that is not their employer. So for a client, let's say. The first category is called in-house lobbyist. The second is called consultant lobbyist. And the final category, which is only exists at the municipal level, but is very important, right, obviously for you and for the industry, is people who don't get paid or particularly volunteers, but do communicate on behalf of an entity that exists for the purpose of profit or that represents members of profit-seeking businesses. The next graphic actually breaks down who is considered to be what. So if we look first of all in the lighter colored boxes, people who are considered to be lobbyists for the association are employees of the association, paid officers of the association, and at the municipal level only. So City of Toronto, City of Ottawa, all the ones that were listed a few slides ago, all members of the board, not paid, but considered to be volunteer lobbyists for OHBA. If we're now looking at any company that is a member of the association, who is a lobbyist for a company that's a member of the association? Lobbyists are the employees of that company, officers of that company, and any member of the board of that company. So we have this little scenario here, which is sort of could arise currently. When are you a lobbyist for the association? When are you a lobbyist for the company? So we take John, for example. So John is a assume John's on the board of the association, doesn't get paid for doing that, but he also has his own company and he derives income from it as an employee and an officer of John M. Smith Housing Co. So, assume it happens that John starts to talk to a Toronto City Councillor about housing supply and about a particular development approval that's being sought by his company, right? John M. Smith Housing Co. He is, in that scenario, both lobbying for OHBA and lobbying for his own company. And he would have to register as a lobbyist for both on the City of Toronto Lobbyist Registry. So it's a simple example, and we can talk about maybe more in the Q&A at the end. But this shows you how you can wear multiple hats, right? And you can oftentimes be considered to be a lobbyist for two different entities. Now, what exactly, we've talked about lobbying, we've talked about lobbyist registrations. What exactly is lobbying? Lobbying has the following elements. Lobbying is a communication, so it involves communication. It's a communication with a person, a type of person called a public office holder. So somebody who holds a position that makes that person a public office holder. We're going to talk about that in a second. And that communication either has to relate to, in many jurisdictions, or be made an attempt to influence something that a government or a council or a legislature does at the municipal, the provincial, the federal level. If those three elements exist and exemptions don't apply, which we'll also talk about, then lobbying occurs and registration will follow. So we'll talk first about communication. Communication just means anything. Speaking about something, emailing somebody, meeting somebody, doesn't matter how the communication takes place. It doesn't have to be a scheduled meeting, and we're here participating in a scheduled Zoom call, but you could run into somebody on the sidewalk or chat casually, and if it has all the other elements of lobbying, it is still something to which lobbyist registration rules apply. And as the slide notes, you don't even have to be in Canada, or you don't have to be in the city or the jurisdiction where the lobbying takes place to have a lobbying communication. We then turn to the issue of what is a public officer? What's this category of municipal, provincial, federal officials with whom you could be communicating? Essentially anybody who works for or holds a position with, elected or appointed, with a level of government, regardless of whether we're talking about the mayor of a city, premier of the province, or a very junior employee in a municipal government or in a provincial ministry or a federal department. So this next graphic just talks about who is a provincial public officer. So if we talk about the province of Ontario, POH in the center stands for public office holders. You'll see at the very top, the 12 o'clock position of this little graphic, members of the legislature. They're public office holders. Going to 2 o'clock, I guess, people who work for ministries. They're public office holders. Going to 4 o'clock, people who work in the offices of MPPs, people who work in the offices of ministers. Talking to them, they're public office holders. If you go to the 6 o'clock position, many entities in the larger public sector, and I'll elaborate in a second, contain people who are considered public office holders, people who are appointed by cabinet or ministers to sit on provincial bodies, public office holders. And then at the 10 o'clock position on this little graphic, ministers of the crown, all of those, so elected, appointed, employed officials, public office holders. So just some examples on this next page. Every entity here has employees who are considered to be public office holders. And for lobbying to occur, you have to communicate with them, has to meet the other elements of lobbying we'll talk about later, but respectively, they are. So we're talking about Infrastructure Ontario. People who work there, public office holders. Communications with Infrastructure Ontario could be lobbying. We see references to the Building Code Commission, to Invest Ontario. Now, some of the other entities on this list are tribunals that hold adjudicative hearings. They're still public office holders. Communication with them may not be, could be, may not be lobbying, depending on what you say, but you got to consider this is the entire universe of public office holders. The full list, there's a URL there if you want to see the full list of entities that have public office holders, and but it only applies to entities that are government entities. So Terrian, for example, not a government entity, not a public body. Its employees are not public office holders. I'm going to go more quickly through the similar federal graphic because it shows basically the same thing of who is a federal public office holder. And I'll go really quickly through the list of federal entities. I mean, these are federal entities, entities whose employees are public office holders, communications with which could possibly constitute lobbying under federal lobbying law. Now, this communication with a public office holder, go to the next slide, to constitute lobbying has to be made an attempt to influence, or in some jurisdictions, just simply be about something that government decides. What types of decisions? Well, pretty much everything, right? Everything from lawmaking, so that could be a bill or a resolution before Parliament or the legislature, municipal council, the making of a bylaw, the making of a federal, provincial law, could be a policy or program, anything that is decided by a level of government. The awarding of funding, the giving of grants, trying to seek those things, that is a decision that a government makes, and communication with the public also about that's lobbying. In many jurisdictions, not at the federal level, not at the provincial level in Ontario, if you're an employee of a company, but if somebody else is helping you, it is, and always where there's municipal lobbying law, talking about contracting with the government, any level of government is lobbying. And at the provincial level in particular, decisions about the sale of assets, or about taking services currently provided by government employees and having the private sector provide them, those type of decisions are the decisions that are subject to lobbying. The next slide goes particularly looks at the issue of municipal permits and licenses and approvals. And as a general matter, there are exceptions, but as a general matter, municipal permitting and licensing and approval is the type of decision that is captured by lobbying law when you communicate with a municipal public office holder about it. The next slide just gives a wide list of the types of, which right, the types of approvals that municipalities grant or give. There are exceptions, which we'll talk about. So that just summarizes this is a communication with a public office holder about or attempt to influence government decision is lobbying, unless there are exemptions, which we'll get to. I want to talk about one other kind of lobbying as well. So we've talked so far about communications that you would have, or one would have, with somebody in a provincial, federal, municipal government. There is a type of lobbying which doesn't involve you communicating at all directly with the public office holder, has you communicating with the public and encouraging the public to contact their city councillor, contact somebody in the government to do that. The definition under provincial law, federal law, City of Toronto law, always the same. This type of communication, called grassroots communication, going to the public in a grassroots forum, is an appeal to the member of the public through mass media, direct communication, so it could be advertising, phone banking, contacting people, which seeks to ask the public to contact public office holders. I will just skip the next slide, simply let you know that when you're engaged in those appeals to the public, you are lobbying, whether or not you actually talk to government officials yourself. Federal law, just stay on that slide just for a second, Kyle. Federal law, very complicated to determine how and under what circumstances lobbyist registration is required. I'll also note that the City of Toronto has an extremely complicated process for the registration and approval of that type of activity. So just because you're not talking to government directly, you're going to the public, doesn't mean you're not subject to lobbying law. At the federal, provincial, municipal level, you often are. In addition to that, in some places, if you don't talk to government directly, public also, but you put a colleague in touch with a government official, depending on how the bylaw is worded, the law of that jurisdiction, you could also be lobbying just by that fact. So we then turn quickly to this issue of exceptions, which I mentioned. What isn't lobbying? Well, sorts of things that you would expect, right? If I'm asking government for information, what is the process? When is this coming before council? What's the status of this bill for the legislature? If there's not an attempt to influence the decision by asking those questions, that's not considered to be lobbying. as well, because, and Kyle's going to talk about what lobbyist registration involves. But lobbyist registration is all about transparency, making things public, posting on a website what's happening. Well, a lot of government processes are already very public. You appear as a delegation before a municipal council, that's public. It's live streamed, its minutes are posted, everybody can see it. Same thing if you appear before a committee of the Ontario legislature or parliament. So those public appearances as part of public processes are not lobbying because they're already public. They don't need to be registered. In addition to that, often we talk to government not to get government to make a new law or change a policy. We simply want the government officials to interpret or apply the law in a particular way. Like this happens every day. The private sector is continuously talking to the government sector about how the private sector is regulated in a particular way. Is my, your health and safety inspector comes, is my workplace right safe or unsafe, or is there a complaint? We dealing with the appeals to what used to be the OMB, the land tribunal. That's an adjudicative process where you're asking the decision makers not to make the law, simply to interpret the law as it applies to a particular application or development. So all of those situations where the government isn't being asked to make law, but simply interpret the law and apply it to the facts of your case, those things aren't lobbying. And similarly, if you are caught up in a proceeding where a government official is making you divulge information or is claiming a power to compel you to participate in a process, the examples we've given are the Ministry of Labor, the Auditor General, the province, all those things. Those you're not lobbying by participating in the process you've got to participate in. In addition to that, depending on the jurisdiction, somebody in government might reach out to you, city councilor, town council might say, what do you think about this thing we're doing? Or you may be consulted as part of a government provincial ministry stakeholder on certain things. Depending on the jurisdiction, depending on how the bylaws worded or provincial law, federal law, you may not be lobbying if you simply speak your mind in response to being invited to do so. But it depends very particularly on the law of the place you are. So one of the big kinds of distinction is whether or not the request is in writing. If you get a written request, saying please come in stakeholders and tell the Minister of Finance at pre-budget consultations what you want to hear, that's not lobbying provincially, and it's not lobbying municipally. It may or may not be lobbying if approached by the federal government to do that. If the request doesn't come in writing, it's just a phone call or oral communication, less likely to be exempt. It depends on the particular circumstances of that case. We talked, and I said I'd come back to this. I talked about municipal permitting and licensing and approvals. Not every attempt to influence those approvals is lobbying. And I'll use the City of Toronto as an example. The City of Toronto essentially tries to separate the ordinary course of a planning or development application and participation in those ordinary course communications, not lobbying. So providing general information, a heads up to the ward councillor, not lobbying. Talking to the municipal staff to inquire about the process and where things are, not lobbying. Communicating directly, as the City of Toronto example, with the employees who have your file, reviewing the application, not lobbying. Communicating, as you're required to do at public meetings, not lobbying. Providing technical information, not lobbying. But everything else is lobbying. So, for example, I said giving a heads up to the ward councillor, just a heads up, we're making this application, not lobbying. Any other more substantive communications about an application with the ward councillor is lobbying. Communicating with officials who are handling your file, not lobbying. Communicating with anybody else in the city who's not specifically assigned to your application file is lobbying. So while there is an exemption for ordinary course communication, there's a lot of activity that is not. And this just uses the City of Toronto example, but there are parallel exemptions, limited in nature, in the other municipalities. So I believe, Kyle, is that over to you?
Yeah. So thank you, guys. So next, we just want to move into a brief discussion of what are the risks. In other words, if there is non-compliance with the act, what are the potential venues that non-compliance can be explored in, and then what are the potential penalties? We've divided this up into essentially 3 different types of legal proceedings. There are administrative legal proceedings. That's essentially where the regulators, such as the Integrity Commissioner of Ontario, investigate. They act as the judge and the jury, for lack of a better term. There's obviously court-based proceedings. Those are formally known as prosecutions, and offenses under this act are quasi-criminal criminal offenses. And there's also other proceedings, and examples of those might be an Auditor General's investigation, a public inquiry, and if any of you follow the Legislative Assembly or the Parliament of Canada or even municipal proceedings, there are also committee-related investigations. And so it's open to parliamentarians or legislators to investigate matters that they see fit. What are the maximum penalties? And again, I put an asterisk on this slide just because the penalties vary from jurisdiction to jurisdiction. The most severe penalties are at the federal level. So the federal level, for example, is the only jurisdiction that allows the Crown, upon a successful prosecution, to seek a prison term. To date, no one has been sent to prison. The largest fine to date against an individual was $50,000 under the federal regime. But depending on the jurisdiction you're in, these are some of the legal consequences. So some regulators have the ability to prohibit you from lobbying for a period of up to 2 years. If you're doing contracting with some governments and you're convicted of an offense, for example, at the federal level, you may be prohibited in the future from doing business with that government. Obviously, there's reputational costs and financial costs associated with successfully defending these sorts of investigations. So this leads into what is due diligence. Well, due diligence is a legal concept, and in some situations, if you can demonstrate that you've taken all reasonable steps to prevent non-compliance, if something slips through the cracks, it may either, depending on the venue, again, that the proceeding is in, it may reduce the penalty, or it may provide an absolute defense and absolve you of liability. So we recommend that clients put in place a due diligence system, again, to prevent inadvertent non-compliance in the first place, and in the event that there is non-compliance, to avail themselves of the defense of due diligence. Generally, due diligence includes, and this is not a concept that's just confined to lobbying law. Many of you be familiar in the occupational health and safety space with this concept, but essentially your due diligence system should include a policy, a process, some kind of education, and obviously monitoring and enforcement of that policy and process. So what is the process for lobbying? So let's assume that you have registered to lobby, you've met the thresholds, which we'll talk about in the next slide, and you actually need to file a registration. What sorts of information are you going to need to compile before you file that registration with the regulator? Again, this is a general summary, so depending on the specific jurisdiction you're operating in, some require more detail, others require less detail. There isn't a uniform approach across the board, but in general, there's different buckets of information that you're required to disclose. The first one is you disclose information on your lobbying activities. In other words, what are you talking about? Who are you talking to? What government institutions are you lobbying? So all of that information related to your lobbying activities. There's also information on the corporate structure of your company. In the case of the OHBA, the structure is pretty straightforward. But in the case of a member company, you might have parent companies, for example. You might have sister affiliated companies. Depending on the jurisdiction you're in, there's varying levels of disclosure that is required. And you're also required in most jurisdictions to disclose if there's any controlling or directing interests that will benefit from the lobbyist registration or the lobbying activities. You're also required to disclose if you receive government funding, or if another private sector entity is funding part or all of your lobbying activities. And there's obviously information on the lobbyists, including if they were formerly employed by the government. And there's a whole host of legal attestations which relate to the ethical rules. So oftentimes when you file these registrations, You will be required to attest that you have read the legal requirements and that you are, to the best of your knowledge, in compliance with those legal requirements. So again, this is generally the sort of information that is disclosed. It's publicly available. There's information on the lobbying activities, your corporate structure, any private or government funding that you've received, information on your lobbyists, and then all of those legal attestations. So if you have to file a registration or update a registration, what's the steps? So I want to start just with filing an initial registration. So if your company has never been registered before, when do you have to register? And if you do register, what is the process? What are the deadlines, for example? And then we'll touch on the subsequent updating after we filed an initial report. It's important to keep in mind that at the municipal level, there's no registration threshold in these jurisdictions. So none of these jurisdictions have said you only need to register if you're lobbying over a certain volume or amount. What that means is that all lobbying must be registered in these jurisdictions. There's no threshold to hide behind. You must register within the stipulated time frame after your first instance of lobbying. As we noted earlier in the slide, Barry's law is not yet in force, but will come into force in the new year. There are different deadlines for registering at the municipal level. And I've created a little chart here. Some jurisdictions, like the City of Toronto and Hamilton, require you to register before you start lobbying. In most jurisdictions, though, you have anywhere from 5 to 15 days to file your first registration after your first instance of lobbying. And so we will distribute these slides after, and we're happy to answer follow-up questions. But again, it varies from jurisdiction to jurisdiction. Some jurisdictions, interestingly, use business days and others use calendar days. But we're happy to sort out if you have questions on that particular point there. But just to flag again for folks on the call who are active in Hamilton and Toronto, those jurisdictions are unique in that you have to be registered before your first instance of lobbying. And it's actually an offense for a public office holder, such as a city councillor in those jurisdictions, to meet with an unregistered lobbyist. So there's actually legal liability on the other side as well. So what about provincial and federal registration? So when do you need to register at the provincial and federal level? Now, unlike the municipalities, there are registration thresholds here. This means that not all companies are going to need to register. You only need to register at the at the provincial or the federal level if you reach these thresholds. So the threshold in Ontario is 50 hours of communication time in a calendar year. That only includes communication time. It doesn't include preparation and travel time. So if your company is on track to hit 50 hours, or you hit 50 hours, you are required to file a lobbyist registration. That's calculated by all the employees, officers, and directors within your member company. It's open to you if you'd like to not get in the business of tracking all this time and get down in the weeds. You can register preemptively. So there's nothing preventing a company from registering preemptively, provincially or federally. Federally, the threshold is slightly different. It's 20% of an employee equivalent, which is approximately 30 hours in any month. But unlike at the provincial level, at the federal level, within that 30 hours or 20% equivalent, you have to include all the preparation time, travel time, and actual communication time. So for example, if you're based in Thunder Bay or Sudbury and you drive to Ottawa or you fly to Ottawa, you have to include that time in the federal threshold. You do not have to include that, as I noted, in the provincial threshold. So the federal threshold is substantially lower than the provincial threshold. So let's say you filed a registration. So you've filed an initial registration either at the municipal level, the provincial, or the federal level. What are the next steps? Well, it's important to keep in mind that lobbyist registrations are not like driver's licenses. So once you're registered, you're not good to continue lobbying. You have to continually update your registration. And in some instances, you have to file special detailed reports setting out your communications with government. The deadlines for filing those subsequent reports or updates vary from jurisdiction to jurisdiction. In the municipalities, you have anywhere from 2 to 15 days, depending on which jurisdiction you're in, to update an existing registration. Provincially, you have 30 days from the date a change occurs. And federally, you have to file updates before the 15th of the following month. So if a change occurs, for example, in December, you have to file that update before January 15th. I won't spend a ton of time on this, but federally, there are these specific detailed reports when you're meeting with senior people, such as MPs, senators, the prime minister, cabinet ministers. There are special detailed reports where you have to set out the specific dates of your communications and what you were talking about. So that's the overview of the registration process. Again, you have to file an initial registration at the municipal level in those regulated jurisdictions. There's no threshold. You have a number of days to file that unless you're in Toronto or Hamilton. You have to be registered before you lobby. And then provincially and federally, again, you file an initial registration once you've met the threshold, or if you'd like to register preemptively, and then you update it in accordance with the reporting deadlines. So what are the ethical restrictions? And here I just want to provide a high-level overview. Again, each jurisdiction has different ethical rules, and the ethical rules are contained in a whole host of different legal instruments. So some of them, obviously, in severe instances involving bribery, for example, are contained in the criminal code. Some of them are contained in lobbying statutes. So if you go to the Lobbying Act of Canada or the Ontario Lobbyist Registration Act, there's different ethics provisions in there. And some of them are also contained in codes of conduct, which are non-statutory instruments that are still legally enforceable. The first group or bucket of restrictions are people who used to work for the government. So they were formerly public office holders. They've left the government to go back to the private sector or to go to the private sector, perhaps for the first time. When you're hiring someone who used to work for the government, you'll want to screen to make sure that they're not subject to any post-employment restrictions. And there's different, again, they vary from jurisdiction to jurisdiction. If your company wants to hire someone, for example, who used to work for a minister in the federal government, that individual is prohibited from lobbying for 5 years. There's different and slightly less rules in Ontario, but there are similar prohibitions in the provincial legislation. There's also in almost all jurisdictions a requirement that people who leave the government keep confidential and protect confidential information that they obtained during their time in government. And that applies until in perpetuity, until the information is no longer confidential. There is a restriction in a number of jurisdictions on simultaneously advising and lobbying the government. And this is essentially a revolving door provision. The government enacted this provision at the provincial level because it didn't want people lobbying the government and then getting a check from the government as well to advise on the same or similar matters. So if you are a part of an advisory committee or you run a business on the side that's engaged in consulting work with the government, you'll want to make sure that you're not subject, or your employees aren't subject to any restrictions that prevent them from lobbying. Again, that would only apply where you're being paid to advise the government on some kind of matter. In most jurisdictions, there's a requirement that you provide accurate information and that you take positive steps to ensure the information you're providing to the public in the case of a grassroots campaign, or to the public office holder in the case of direct lobbying is accurate. This is just a provision of the federal code. There's similar provisions, for example, in the City of Toronto's Lobbyist Code of Conduct. Close relationships. So this comes up quite a bit. So an employee of your company has a relative who works in the government, or they have a close friend, or perhaps they have a business partner who they own a cottage with or something. Can you lobby that person if you have a close relationship with them? And the general answer is no, and there's different rules in different jurisdictions. But for example, at the federal level, the regulator has said you can't lobby anyone in government if you share a close relationship with them. And they've defined that as a close bond that extends beyond being a mere acquaintance. And so examples there would include your child, a dependent child who works for the government, your partner, your wife or husband who works for the government, and as I noted, any close business relationships, so people you own a company with or you own a property with. In those instances, you should not lobby that person. There may be exemptions. The person may, for example, not be sufficient enough to trigger the close relationship, but you should screen that in advance of lobbying that person. You run the risk if you lobby people in the government who you share a relationship with, that you will both be found to have violated a code or a provision in an act, but also that individual may be exposed vis-a-vis their employer or the government, which has a bunch of ethical rules that apply to its employees. Gifts and hospitality, this is another very common area where we get a lot of questions. As a general rule, there are restrictions on giving gifts. Those would apply to lobbyists or people in the private sector. There are also restrictions on receiving gifts, and those apply to the people who work within the government. It's important to check both of the rules because you don't want to give a gift that perhaps you're allowed to give, but the public office holder is not allowed to accept. And there's obviously different provisions in different statutes. At the most severe levels, it can involve the bribery provisions or fraud on the government provisions in the criminal code. We strongly recommend that you consult a lawyer prior to giving any kind of gift to the government. And again, the rationale for that is that most of these jurisdictions make it an offense merely to offer a gift. So even if you offer a gift and you claw it back or you don't actually give the gift, there's still legal exposure. So it's always best to check the specific rules prior to offering to give a gift to a public office holder. A gift can include anything. It can include cash, it can include gift cards, it can include trinkets, it can include meals, hospitality, drinks, private dinners, anything that is basically given for free or given at a reduced value to someone in the government could be construed as a gift. There are exceptions, and again, we recommend that you examine these exceptions prior to offering the gift, but most of the jurisdictions that have exemptions have a two-part test. So there's usually both a quantitative test, the gift has to be under a certain amount, and there's also a qualitative test. Is this an appropriate gift? Generally, for example, you are not allowed to privately wine and dine public office holders in any jurisdiction in Canada. That's something that would not meet the qualitative test, even if it's below the quantitative test. So it's important when you're looking at those tests that you keep in mind it's a two-part test, and you have to satisfy both parts of the test in order for that gift to be exempt and you be allowed to offer it to the public office holder. The last restriction I want to just highlight here is political work. So what happens if you, for example, hold a fundraiser for a provincial candidate, you raise $20,000 or $30,000 for that candidate and they get elected and they become an MPP or they become a cabinet minister? Can you turn around and lobby that individual? And there are rules across the board incorporated through different provisions. Some of them are direct rules, some of them are indirect rules that generally prohibit you from lobbying people who, when they were a candidate, you were doing different types of political work for. Fundraising is an example. If you're preparing someone from a debate, if you are managing someone's campaign, etc. And there's different rules by different jurisdictions or in different jurisdictions, and those rules treat different types of political activities differently. One thing that is never covered is if you make a personal contribution to a political candidate. So you're not fundraising from other people, you're not asking other people to donate, but you make a contribution. That is never something that would restrict you from lobbying that individual. It does get, as I noted earlier, murky when you start organizing fundraisers and trying to get family and friends to donate money. And Guy and I have defended a few people who have been investigated by the Integrity Commissioner for that sort of conduct. And so with that, we're happy to open it up to questions and answers. We have just under 15 minutes left. Again, this is being recorded, so I would just caution you, if you have a specific question about your company or a specific legal exposure, it's probably best to save that question for offline, just so that it doesn't get presented on the recording and maintained on the OHBA database for everyone to see. And if we don't get to your question today, we're always happy to follow up with you. We offer a number of services to private companies, and sometimes companies just want to outsource all of this red tape. And so if you're interested in learning more, you have specific questions about a specific situation, we're always happy to follow up with you, Guy or I or any other member of our political law team. But with that, Emma, I might open it up, I guess, to the questions and answers here.
Thank you, Guy and Kyle. I think we have a few questions, but perhaps I might get things rolling a little bit. And I want to go back to the notion of this grassroots concept. And in a world of social media, Twitter and Facebook, whatever platforms people may use, is posting or eliciting suggestions of policy preferences by either an association, individuals, or a group of individuals considered lobbying. And I want to make a distinction between what a person may post, an association may post, and political or media campaigns during, say, a pre-election, in a pre-election writ period.
Wow, lot to unpack there. What, Cal? There's so many issues here. One is what is grassroots lobbying. Then there's the whole question of personal versus corporate, and then there's the issue of elections. So let's begin by saying, in any case, absolutely, social media is covered, is covered, but there has to be a call to action, and that call to action has to be encouraging the public to communicate with public office holders. So if it doesn't have that test, it's just share your views with us, or what do you think of this, or we're taking a survey, not lobbying. But if it has that element of calling to action, contact government, either generally or specifically, it is. Kyle, do you want to jump into when a personal tweet or something like that is or is not, and what a corp company thing is and stuff like that?
Yeah, and I would say, Neil, it's a really good question, and it's a very complex area of the law. And it also delves into some, depending on if you're in an actual election regulated sphere. Again, the focus of today's presentation has been on lobbying laws, but if you're in a regulated period under election laws, there's also specific rules that apply to that, certainly during an election campaign, but also in the lead up to an election. So right now, we're not in a regulated period in Ontario for those election laws. But as we get closer to an election, we will eventually do that. There will be a lot of contextual factors that will need to be taken into consideration in any given situation. So for example, if you're a paid employee and you are tweeting or posting on social media or organizing a grassroots campaign during company time, you likely are doing that on behalf of the company. If you're being compensated to do it, it's coming from a company account, for example, and it's advocating for some kind of interest that the company is affiliated with. Generally, though, if you're on your personal social media outside of working hours and you're advocating for things that are unrelated to your business, let's say, for example, you're passionate about mental health initiatives, and so you're advocating for mental health initiatives on social media from your personal account, that's generally not something that would be covered or you'd be required to register under your company's lobbyist registration. It might get murky, though, if you're in a situation where you're advocating for policies, specifically in the housing sphere, that your company in the OHBA has a specific position on, has an interest in, will benefit or be harmed by, depending on what approach the government takes. In that case, the regulator will look at a number of factors. So were you doing it during company time, et cetera, et cetera. So it certainly can be regulated. Keep in mind, though, a grassroots campaign, it has to be a campaign. So you have to be encouraging members of the public to contact a public office holder. So an example would be in the city of Toronto, contact your local city councillor and tell them that you want more housing supply in the city of Toronto, or you want bylaws and regulations that are more friendly to the housing industry. If you're involved in organizing that campaign and pushing that information out, then you're very much required to register. If you're retweeting something, though, that's probably not at the threshold where you've triggered that. But again, it's always good to check in advance just to make sure.
So Neil, it looks like we have 6 questions already in the chat. Do you want to do a minute each, Kyle? We can see if we can knock these off quickly. I think.
Yeah, no, please go ahead. Thank you.
So the first one from Tom was the nuance about the interpretation of regulations and laws. I'll simple here. Sometimes you want a solution, which is the law doesn't apply, the law doesn't restrict this, but if the law does, then change the law. That's the answer of nuance. If you're asking for a bylaw or a regulation or a legislation to be changed, that is lobbying. If you're arguing, look, we're not trying to change the law, just interpret it differently. It doesn't apply to these facts. It shouldn't be interpreted that way, not lobbying. And I point out, yes, sometimes in a business you do both. Kyle, the next one, give this to you. If we lobby the provincial government less than 50 hours, do we need to do anything?
Yeah, so the simple answer is no. If you're below the 50-hour threshold in a calendar year, and again, that only includes communication time, so that's quite a high threshold, you do not have to register. But you will want to have some kind of tracking system in place. So if the regulator comes to you and says, well, we were made aware that you met with the minister on multiple occasions to discuss housing supply, why aren't you registered? You'll want to be able to say, well, we have a tracking system in place and we are well under the 50-hour threshold. But you are correct, if you are below the 50-hour threshold in Ontario, you don't have to do anything, you don't have to file anything.
Stacey, do any municipalities have voluntary registry, not mandatory? In the province of Ontario, no. Outside Ontario, which we can talk about if you're interested, yes. There are some jurisdictions that come online that have a voluntary, a non-enforcement period before they start enforcing it. And if that's possible, that some future ones that come online will do the same. But they're typically mandatory in the province of Ontario. Kyle, do you want to see to the next one from Mohammed? How do we differentiate between advocacy and lobbying? Advocacy for reduction of red tape or asking community to hold duty bearers accountable, even if these are related to our businesses, could still require registration? Yes. I think.
Well, and I would just tack onto that. Most times, actually, and I believe the provincial government in Ontario is certainly doing this, certainly in Alberta, the provincial government is doing this. They'll often set up red tape reduction panels, or they might even have a minister that's responsible for red tape reduction. So if you are advocating for a reduction in red tape, i.e. the permitting process, the regulatory process is too complex, too burdensome, and obviously this is a live discussion given the policy discussions that are taking place right now with housing, that's certainly lobbying. You're advocating for a change to the underlying system. You're no longer just applying for a permit or going through a regulatory process. You're actually trying to change the underlying process, make it simpler. So that would be lobbying.
So the next one, it comes up a lot, and just to get to the heart of it, there are a bunch of there's one or more people who are registered as consultant lobbyists, and you attend a meeting with them. Does the fact that they're registered cover you or anybody else? The answer is no. If there's a bunch of people attend a meeting, they are all subject to lobbyist registration, and the fact that consultants registered doesn't get you off the hook to register. Okay. Going through the next one, how the enforcement of the registries works? Is it complaint driven, or are these officials actively reviewing the registrations? The answer is both. Right? I know, just in the interest of time, I will simply say both. So you're subject to complaints from members of the public, complaints from competitors, complaints from people inside government, and as well, there are staff members who are reviewing the registrations and are looking, are they timely, are they complete, all of the above. Kyle, what if you have ministers, federal or provincial, as guest speakers? Does that count as lobbying?
Well, so that's an interesting question. Again, it's going to depend on the circumstances. So if you invite a minister to speak at a public event that's broadcast, probably their comments are not, there's not going to be any lobbying around the invitation, for example. But if you had a sidebar conversation at your event and you said, you know, oh, by the way, that was a great speech. Thanks so much for coming. Can we just take 5 minutes to talk about your government's approach to X, Y, or Z? You know, as an association or as a company, we think you should do X, Y, or Z. You've delved into the lobbying sphere. So yeah, it's really context specific, but just inviting someone to speak, letting them speak, and limiting your communications to the invitation and the ironing out of logistics, timing, those sorts of things, that would not in and of itself be lobbying.
And I think the last one that's open, we did answer about the 50 hours from Pierre. So I think that's, you know, I think we've covered everything that was in the chat.
Okay. Just one other question. The Planning Act has evolved over the last several years to a world where there is a lot more pre-consultation required prior to filing the application. And that could include, you know, formal meetings with staff. It could include conversations outside of the realm of a formal pre-consultation with the counselor or his or her offices. Where's the line on that with respect to lobbyist registration?
So I'll start with the piece, just I'll note, to add to the record, you haven't mentioned the province, seeking an MZO, always lobbying. So cover that off. The second thing, municipally, it depends on very specifically on the wording of the bylaw and the specific communications. I said the general thrust is to attempt to just separate ordinary course, which is not lobbying, from anything outside the ordinary course, which is. So yeah, the City of Toronto's example, you know, they do note that you've got to have some consultations, that you're required to do that, so you're not lobbying. They do suggest there's active review. As a political matter, they even added, you know, letting the council know you're doing that. But again, you got to go to each particular bylaw, but there's in its own way, every city and every town is trying to separate things that they consider routine, which are not lobbying, including those processes you've identified, and those which go beyond that, which are lobbying. And I can't be more than that. So typically, you know, like if we're helping a company with this, we actually go through, okay, what are the communications? What have you said? What did you hand over? Who's the meeting with? And you know, oh, that's lobbying, that's lobbying, that's not. It really is that kind of a specific, you know, communication by communication, a meeting by meeting exercise.
Thank you. Seeing that we're two minute warning here, there's no other questions. I think what I'll do is I'll wrap this up, and I just wanted to reiterate my comments at the beginning of the session. As you could appreciate, I think we've scratched the surface of a very, very complex conversation and legal requirements that exists certainly federally in Ontario and in a number of municipal jurisdictions, and a growing list. I think the spotlight that has been paid to our sector through recent media and parliamentary investigations, we saw this as a necessary piece of information and tool to our members, because we are constantly in the political arena on a day-to-day basis. I think the fine line here is the point to get across, that it's a very nuanced relationship. Practice prudence at all times. When in doubt, probably your gut reaction is, I should double check and double down on my activity and whether or not I have registered or not. So with that, I want to thank Guy and Kyle for their expert advice, their counsel, and I would encourage our members that should they require further, you know, information, insight, or opinion, to reach out to Kyle and to Guy and the team at Fasken's. We appreciate that time and effort that you've put into this today. gentlemen, and I wish everyone a great day and a excellent and happy holiday season ahead. Thank you so much.
Thanks, everyone. Bye-bye.
Thanks, Kyle.
Okay, no worries.
Thanks
Thank you
so
so
much.
much for having us.
Thanks, Scott. Yeah, appreciate it very much.